Hello, good evening and welcome to UPfront. My name is Raymond Alqua. Tonight, the minority in Ghana's parliament has dragged the Attorney General to the Supreme Court over the recent approval of the electronic transactions levy, that is the E-Levy, in the Parliament of the Republic of Ghana. What are they really asking for? And at the core of it, what is the main issue at play here? All of the other questions on your mind is what will be the subject of our interrogation with a man competent enough to participate in this conversation. The former lecturer, he used to teach. Then he became a politician of sorts. He's a member of parliament for the Bolgatanga East constituency. He's also the subsidiary legislation committee chairman of parliament.
That is so.
And now you know that he's also a former deputy attorney general. Perhaps the brain behind the current decisions of the minority in parliament, whether that backfired, whether that was a poor strategy, all of that will be discussed on UPfront today. You're welcome, sir.
Thank you very much for having me.
I hope you are doing well.
I am doing well.
It's been a long time.
Yes, I'm trying
to get an interaction. When you, the distinguished big men in this country, shun opportunity to engage the ordinary people, it will be unfair to them, isn't it?
That is not true, Raymond. You know, I have been engaging with ordinary people on a daily basis.
Oh, I see.
In fact, when I go to my constituency, I am not attired in this way. I wear maybe a jeans or khaki shorts, and then slippers and T-shirt or a smock. And I roam with my foot soldiers everywhere, nook and cranny of the constituency. And even here in Accra, you know, I do roam, you know, I do associate and interact with ordinary people every day.
Even with the PhD for Stanford?
Well, I mean, that doesn't make you, I mean, a superhuman being. And I don't wear my PhD on my shoulders. I mean, I'm not somebody who is fan of titles and insisting to be addressed as Dr. Ayene and so on. If you call me Dominic or Akurutenga, actually I prefer being called Akurutenga.
Which you have been trying to do, but it's a bit of a, I'll get it.
No, I don't
get it wrong. Akurutenga is, I tried to say it nicely.
Oh, you've done very well.
Oh, yes.
You've done very well.
I rehearsed it ahead of
Yes. So,
anyway,
okay.
But I hope you are doing well.
I'm keeping well.
Because you've been in trouble recently. I mean, with the General Legal Council and all of that. Is that having any toll on you and your work?
No, not at all. Not at all. I'm actually, I mean, used to being in trouble, especially when it is good trouble. I like getting, I mean, into good trouble. I think that the comment that I made, you know, by, you know, on the CDD platform, on my subjective view of the independence of the judiciary is something that an academic of my standing is any ordinary citizen can make, and especially in exercise of my right to academic freedom. So I am busy with my lawyers, Tony Lita, and then the former Attorney General, you know, defending myself before the panel of the General Legal Council. So I am not really too bothered about it. I know the consequences. I know that ultimately they could take away my license. I know that I could be suspended as a lawyer and so on. Yes, it is that grave. But you see, as a man, you have to stand by your principles. And if you believe in, you know, what you say, you have to stand by what you have said. So that's the kind of person I am. But
it's interesting. We should also get that means that there was one of the questions I was hoping to sneak in.
Yes.
But at the tail end of it, what the former President Mahama has been saying about the judiciary, I was hoping that would not get you more trouble.
Well, I don't think that I would want to comment, you know, on anything now regarding the judiciary, except with respect to the happenings in Parliament. I think that out of deference to the Chief Justice and then his colleagues on the bench, you know, I think that it is only proper that I do not continue to run any commentary on the activities of the judiciary in a way, especially that will, you know, send a signal that I do not care about what, you know, I say.
I understand
regarding a very important, you know, constitutional institution. I mean, that is also the institution before which I earn a living as a lawyer.
You are an officer of the court, the consistency.
Yes, I'm an officer of the court.
Okay.
Yes.
Now, let me bring this home. Because you're also a member of parliament.
Yes.
In fact, you're one of those that really come in when there is any constitutional issue that requires some form of help. And the parliament is finding its way around it. And you lead some of these engagements.
Yes.
Now, on the day the E-Levy was passed, or was
that was yesterday.
That is yesterday.
Yes.
The minority walked out.
That is so.
The decision to walk out, did you influence that decision?
I wouldn't say I influenced that decision.
Were you part of that decision?
Well, I have always been part of, the crop of lawyers advising the front bench, advising the leadership on legal matters.
I see.
But as far as yesterday was concerned, my position was different. My position was that we should bring in the Asinov, member of parliament to participate, in the voting. And I remember distinctly that there was a phone call between a very important member of our party, and then the Honorable Atufosin. And that person asked me specifically what I thought about the participation of the member of parliament for Asinov. And I told him, without any reservations, that for me, the legal processes so far did not serve as a bar to the participation of the member of parliament
for a recent court in the Cape Coast or so in the central region that actually thrown out his
so Raymond, let's you see,
disintegrated
the appeal. Let me deconstruct it for ordinary people. For non-lawyers, not ordinary people. You see, the appeal was not dismissed. In law, when your appeal is dismissed, then it means that on the merits you have no case. That is the thinking of the Court of Appeal or the appellate, court for that matter. When your appeal has been struck out, it means that you have not complied with a procedural step that you ought to have taken in order for your appeal to be heard. So in this particular instance, when the notice of appeal was filed against the decision of the High Court in Cape Coast, the requirement of the rules is that you should file the legal arguments within 21 days of the notice of appeal. Now, the legal arguments were not filed within 21 days. So, after the 21 days, the Court of Appeal, struck out the notice of appeal. But what it meant, and all the subsequent processes that were, dependent on the notice of appeal. So, for instance, you can make an application for stay of, execution and so on. All those processes are dependent on the originating process, which is the notice of appeal. So when the notice of appeal was struck out, all those processes were also thrown out. But when your appeal has been struck out, then it means that you can relist, you can apply to relist it so that the case is heard on the merits. And the court will then give you a date to file your legal arguments. So technically, the appeal is still pending in the sense that, yes, there has been, an application for relistment of the appeal, which will be heard. And it doesn't matter. No, it doesn't matter. Once the process is with the court and the court is seized with jurisdiction in the matter, you cannot say that, the person you cannot prejudge the outcome. And so the application... Are there not differing opinions on this particular note that you cannot do anything to prejudge it? Is it not other school of thought that suggests that, well, because the status quo today is that there is no injunction of stay or there's no application granted? Yeah, there is a school of thought that says, and I had to engage with that school of thought yesterday. There's the school of thought that says that because the High Court, had dismissed, had given a judgment in which it said that his, election was null and void and of no effect, and that it gave an order to restrain him from putting himself out as the member of parliament for Asinov. Yes. All right. We were back, and because of the striking out of his, notice of appeal, we were back to the, what do you call it, the status quo, right? The status quo ante, which is the High Court decision. And therefore, that school of thought was
which means he should stay out of parliament.
Right. That was the school of thought. And in fact, when I was pushing for him to be brought in to participate in the voting, one of those persons, who expressed this view, which, the person is not a member of parliament, but a lawyer outside of parliament, told me that, did I consider the possibility that a contempt of court application could be brought against him? And then, if the contempt, he's convicted of contempt, he could actually go to prison, all right, for, a period of time. Oh, I see. And that period is indeterminate in the sense that, there is no, what do you call it, a limitation with respect to the sentence that can be imposed. At least I haven't seen one, in relation to contempt of court. So, because of that, there was some, hesitation on the part of some of our members. And I was one of those who developed cold feet because I was pushing for him to be brought in and then to take part in the proceedings. So as far as the political legal strategy was concerned in Parliament, my stance was that let us bring in the sin enough,
and damn the consequences,
and then damn the consequences. But of course, I also realized that the MPP could do one thing, which I anticipated, that is to object to his participation. One, go to court and say that his vote is illegal, ring fence that vote and take it out, which then meant that we would be short by one number. But of course, I mean, in terms of the political optics, I was, willing and pushing, for that angle. Until another legal, political legal strategy was brought into play by the Honorable Mahama Yarga. Okay. And that was a tactical move that we should, we should, leave the chamber and deprive the MPP of the numbers needed for a quorum. Okay, I endorse that opinion because it reflected the true position of the Supreme Court decision in Justice Abdullahi and Attorney General.
Do you agree with that decision?
We will come to that decision.
But let us not take in terms of. I'll not stop you from your point.
Because that is the position of the law now.
Brilliant. Yes.
The question whether I agree with it, we can reserve for another time.
We'll look at
it. But when that position was communicated to leadership, okay, the proponent of that position actually asked my view, and I said that is a correct interpretation of the Supreme Court decision. All right. But whether or not it made political sense, okay, to push that, to its logical conclusion, I wasn't part of those who pushed, for that position. But I endorse the legal, correctness, of the position that was taken. That if we walked out, all right, they will have 137. At most 137 people. The chieftaincy minister was not actually physically present on the floor.
But we saw an ambulance that suggested that he's been brought there.
Well, an ambulance is not a chamber of
admitted.
It's not a chamber.
So you're saying that you were on the floor. He was never brought.
He was never brought into the chamber. All the way until when we left. The chamber of parliament. He was not brought in. So as far as the physical presence of the members on the majority side was concerned, we were convinced that there were 136. Okay, and that is why from the beginning, I was thinking that in terms of the numbers game, if we had 137 and they had 137, right, any vote, could have resulted in the motion for the adoption of the report of the second reading being lost because it meant that, under the Constitution as well as the standing orders, anytime there's a tie, then it means that the motion is lost. And so I was pushing, for that angle until this other strategy, came. Okay. So
I'm actually a very simple question at this point. From the post-facto rationalization of what has happened so far, do you think that the decision to leave was a poor decision?
There were a number of options. Okay, and one option was to deprive the majority of the quorum needed to proceed with the e-levy. In fact, really, realistically speaking, I didn't think that the majority would act in accordance with principle and say that they were not going to proceed.
Because of the quorum issue?
Yeah, because of the quorum issue.
Why would anybody not think that? The Supreme Court has decided. It's the highest court of the land.
So if they were...
presumption that that's the position of the law.
Raymond, you see, if they were acting in accordance with principle, okay, that's what they would have done. In fact, the majority leader should have been the one rising on his feet to draw Mr. Speaker's attention to the fact that, all right, given what has happened, they lacked quorum. But you see, that is where I think that Abdullahi and Attorney General has done Parliament a lot of injustice. Because...
What I say?
Yes, because you see, Parliament...
I want people to follow us.
Okay.
So let me hold on to that point because we'll come to it.
We'll come to it.
There's a question that's been making the rounds on social media. I'm not sure you have seen it. Your votes and proceedings for yesterday is actually being shared.
Yes.
The presumption here is that you didn't even have your 137 or 136 in the first place. Indeed. Some are referencing the fact that Honorable Abdul Latif, they follow in fact on page 8 of the votes and proceedings. Honorable Abdul Latif of Abeokuta Central, Abdul Salam Adams of New Edubiase, Amankwa Nicholas of Amenfi East. Many of these, Avoka, Cletus Apu Zebila, Boatin Joseph Apia,
Raymond, can I stop you?
You are saying that these are MPs.
They were physically in Parliament. I saw Latif and actually greeted. No, please.
This is your official record.
Yes, the official record. I'll come to that. Raymond, I actually interacted with each one of them. The member.
All of this.
Yes, I'm telling you, on our side. You know, because two of them in particular, the Honorable Cletus Avoka, a very senior member of our caucus, all right, is a member of the Subsidiary Legislation Committee.
Yes.
And the previous day we had met on Monday on the business of passing the housing regulations.
Okay.
And so when I met him, he asked me why I had not come to the caucus meeting. And I said, look, because I chaired the previous day, I chaired the meetings till 6:30. I was very tired, so I woke up late. All right, so I interacted with Avoka. In fact, Abdul Latif, I greeted him before he entered the Chamber of Parliament. And the member for New Edubiasi, I call him the member for New York. All right.
Okay.
So I remember distinctly that I also interacted with him, you know, when he came and I asked him, he said he was going to Kumasi to watch the match and so on. So you see, the votes and
so all of them, they were there. How was it corrected today?
Because of the state of the nation, they were not corrected. Usually the votes and proceedings will be corrected. A member will rise on his feet and say, Mr. Speaker, I was here on this day, but I was marked absent. And then Mr. Speaker would direct the table office to correct. So as for correcting the votes, we had all our numbers intact. So people should dismiss this. Or they should dismiss it with contempt. Even the member for Asin North, was in his office. Because of the uncertainty regarding whether he should come or not, he was in his office. So this is something that we should not pay too much regard to.
Now, it's interesting because this is basically saying that no, your argument could not stand any proper scrutiny because you don't have the numbers in the first place.
Right.
And there's evidence on the face of it suggests that you didn't have it.
The evidence.
When will this be corrected?
When will
this be corrected?
Tomorrow.
Yeah.
Tomorrow it will be corrected. Because tomorrow, unlike today, where because we're receiving the president, we did not have the time and the space to be able to do it. Definitely tomorrow, all these members, and Raymond, you can watch all these members. Can this be used as evidence against you in your court case currently before Supreme Court? Oh no, it cannot. Because you see the evidence of the quorum. That's conversation is also about numbers. Yeah, it's about numbers. It's about the majority's numbers. Yeah, it's about the majority's numbers. Okay. So we walked out and they were left in the chamber. So in the determination of quorum, it is only their number that matters. It is only their number that matters. Those who remained in the chambers, in the chamber of parliament at the time the decision was made, and that is why it is important, that we also go on to talk about Abdullahi. I'll get to that point. Yes. Before we talk about Abdullahi, there's already a member of your party, a former minister, whose views are very much respected. Right. A decent lawyer by all standards and qualifications. Right. The Honorable Inus Afuseni says that you have a very slim chance at the court. I don't know the basis of his assessment. No. Because he's I don't know. Has he looked at the rate and the reliefs that have been endorsed on the rate? So let me quickly bring to your attention. It says here there's an important point. Yeah. It says there's a big issue that has to be determined by the court. It says assuming that all others apart from Adjoa Safo and the Chief Justice Minister were present in the chamber, what the minority needed to do was just to leave one person in the chamber to raise an issue of quorum. That way, you'll be invoking the jurisdiction of the speaker to rule on whether there is a quorum for decision to be made or not. And that you have this is the point. He said it's a slim. Reading Abdullah's case, that case stood on whether or not quorum had been formed for the purposes of a decision and whether or not in determining the quorum under 104, the speaker can count himself in as a member of parliament. Yes. That was the Supreme Court. That was what the Supreme Court was invited to answer. Yes. I think they answered us. Whether the quorum is self-invoking is another matter. So his point is that this issue about whether or not a quorum is self-invoking cannot be determined by the Abdullahi case necessarily. Well, the question whether or not there was quorum, there was quorum. Sorry, it's a question of fact. Yeah. Right. But who to raise that matter is and when you are raising it in the Supreme Court, there is evidence. In terms of the proceeding, the record of proceedings in Parliament will show how many people remained on the floor of Parliament for purposes of that decision. Yeah. All right. So the fact that none of our members stayed in order to raise the issue of quorum is not fatal to our case before the Supreme Court. The Supreme Court cannot say that just because we did not raise it in Parliament, all right, because a finger was not raised in Parliament, a finger cannot be raised before the court. We cannot be shut out from the House of Justice. on the basis only that we failed to do what was required of us as members of parliament. In fact,
many people are suggesting
for a constitutional,
that,
I want to make that point. I mean this point that for constitutional litigation, okay, it is not a prerequisite that you ought to have done something before you can allege that a breach of the Constitution has taken place. Once you are alleging a breach of the Constitution, all right, and in terms of Article 2 of the Constitution, you can go to the Supreme Court and seek a declaration to that effect. In fact, supposing you, Raymond Archer, were the plaintiff, would the Supreme Court be right to tell you that you didn't raise, the issue of quorum in Parliament and so you cannot come? But you are a citizen of Ghana.
Because I'm not a parliamentarian anyway. I could have raised it on the yes.
No, yes. So
I get your point.
So it's not, there is no jurisdictional bar just because we did not raise the issue of quorum, in Parliament before leaving. All right. It's a matter of record that can be objectively determined that there was no quorum, that 136 people took the decision on the motion for a second reading. On the consideration stage, all the clause by clause, voting took place, all right, presided over by Mr. Speaker, with 136 members on the floor. Then also during the third reading, the motion for the third reading of the bill for its passage was also, voted upon. The question was put and then they voted upon it. Those are all decisions that were taken by 136 members of Parliament. And we are saying that by so doing, they have, breached, they have contravened Article 1041 of the Constitution. We are inviting the Supreme Court that said that the absence of quorum, that means 138 members of Parliament, being in the chamber, all right, present and voting, okay, renders a decision taken unconstitutional to affirm its own decision in Abdullahi.
I'll get to that point in a jiffy.
Yeah.
But there's an important point that's being made here. Would a proper interpretation of the issues raised by the Honorable Idris of Sedi not be that he's saying it's not open and shut like the way some of you are making it look like because of Abdullahi, clearly the case has ended. He believes that the determination will include whether or not the issue of quorum is self-invoking.
No, it's not self-invoking. It's not self-invoking.
And that is why ought to be determined.
And that is why Abdullahi is bad law.
Okay, now that's the confusion.
That is why Abdullahi is bad law.
You are relying on the bad law.
Yeah. That is why Abdullahi is bad law. And the Supreme Court should tell us why, all right, Abdullahi is inapplicable in this case, bad as it is. Because, and I'll tell you why, this in my view, okay, Abdullahi was a solution in search of a problem.
That's the other way around. That's what they cut before the horse.
Yeah, Abdullahi was a solution in search of a problem. When the Honorable Justice Yoni Kulindi said that, Article 140 is not unambiguous. That is, there is a bit of ambiguity. What is ambiguous about Article 141? It is very clear that you should have it says, except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting, with at least half of all the members of Parliament present. All right. Now, when you say that there is ambiguity with respect to this provision, what do you mean? Is it that we don't understand the mathematics of Article 041? Or that it is unclear with respect to how many members of Parliament are supposed to be on the floor, because we are 275 members of Parliament. Okay, half of that number, because there's no half a human being, is 138. Okay. All right. So that is the baseline number for decision making. Okay. So what is ambiguous about this? But what we are seeking to do in the writ that has been filed by the minority leader and his two, honorable colleagues, all right, is to invite the court to just enforce Article 1041 to say that, when the decisions were taken, the quorum requirement under 1041 was not met. It's as straightforward as that. We are not asking for an interpretation. We are asking for an enforcement because,
you believe that
it was breached.
Of the court is applicable.
No, not interpretation. We are not invoking the interpretative jurisdiction of the court.
No. Okay. So that we can.
Yes.
You believe that what the court said in Abdullahi is applicable in this case?
Yes, very much applicable.
And that you want the court to apply it to this case?
That is so.
That's all that you're asking.
That is all that we are asking.
You're asking the court to do something simple, that you said when half of us are not there, we cannot make a decision.
That is so. Half of us were not there, and a series of decisions were taken. And so we are inviting you, all right, to uphold the Constitution in Article 1, 04, clause 1 of the Constitution.
Yes. No, but it's an interesting mix of this.
Yes.
But in your personal opinion, you think that Abdullah is bad law? Why?
Yeah, Abdullah is bad law. Okay, for a number of reasons. It is bad law because way back in 1979, in 1980, in Tufo, the celebrated case of Tufo and Attorney General, SOA JSC, as he then was, said something very profound. All right, he said the law and custom of Parliament is not known to the courts. That is a very profound statement. What is the law and custom of Parliament? All right, it is about the standing orders, the practices and procedures, the time-honored customs, and practices adopted by Parliament for the conduct of its business. All right. So, for instance, when it comes to the questions of quorum, all right, quorum is presumed, all right, until raised. So, the quorum for the conduct of business is 1/3 of the members of Parliament under 102 of the Constitution. So, on account of 102, all right, when the business of Parliament is starting at any point in time on a certain day, and a member of Parliament says, Mr. Speaker, rises to his feet and says, Mr. Speaker, we do not have quorum. Okay. Then Mr. Speaker will call for a head count and then say, it is true. Indeed, if you don't have 1/3 of the members of Parliament, then business will not continue. Then they will ring the bell. Okay. Now, ringing the bell is not in this Constitution. Okay. Ringing the bell is in the standing orders of Parliament. All right. They will ring the bell, I think 10 times. And when on the 10th occasion, members will begin to troop into the chamber, all right, for business to continue or to commence, as the case may be. Now, when it comes to decision making, quorum is again presumed until raised. So I'll give you a very good example. When we enacted the Companies Code, the Companies Act of 2019, there were less than 30 of us in the chamber. When the third reading was done, there was, less than 30. It was myself, Inus Afuseni, on our side, Inus Afuseni, Honorable Ahiefo, Honorable Roxinda Fiamako, and so on. On the side of the majority, it was just their lawyers, people like Kwame Anyimedu, Honorable Banda, and so on and so forth, okay, with the majority leader, okay. So we were less than 30. By what Abdullah has done, the Companies Act as enacted is unconstitutional. Because we were not, half of the members of Parliament in the chamber at the time that we passed the Companies Act. All right. Even some of the
interpretation, can it take retroactive?
Oh, no, it won't take a retroactive effect. But I'm just telling you,
I get
the seriousness of what has of the decision. Even some of the Supreme Court justices. Okay, but this when they were it's important to make this point. Okay, when their nominations came for approval, we didn't have 138 people in the chamber. We should go and count. So are they unconstitutional judges sitting there? They are not, because quorum was presumed for purposes of the conduct of the business of Parliament.
So what's the basis of this principle you talk about? The quorum is presumed until it's raised.
Yes.
What's the basis of it?
Well, that is what SOA JSC, as it then was referred to as the law and custom of Parliament. All right, because you see, for instance,
but if a court is asked to do an interpretation of specific provisions,
the court has to be mindful of the no.
But regardless of your customs, no matter how it is not subservient to the highest law of the land.
Raymond, if you read Article 110 of the Constitution, it is very clear that Parliament, can enact standing orders to regulate its own procedure.
To the extent it's not inconsistent with the Constitution.
That is so. They say subject to this Constitution.
Yes.
Now, when I read Abdullah, there is an explicit reference to a constitutional provision that has been undermined or that has been contravened by our standing orders. In fact, what the standing orders have done is simply to fill in the gaps in the Constitution. All right, so that Parliament can work efficiently and effectively in delivering the business of government. And so to say that you have contravened a constitutional provision, or you have acted inconsistently with the constitutional provision because you have enacted a standing order that contravenes it, you must point to a specific provision of the Constitution. When you read Abdullahi, there is no such thing. They are invoking something, akin to the spirit of the Constitution. Basically saying that, hey, you know what? Every member of parliament is endowed with the right to vote. The first deputy speaker is a member of parliament. Therefore, logically, he has a right to vote. And because he has a right to vote, the standing orders cannot say that when he is presiding, he cannot be counted for purposes of a quorum. That is the reasoning. In summary, that is the reasoning of Abdullahi. And what Abdullahi has done is to do injustice to the business of government. Because anytime we don't have 138 and somebody decides to raise a finger, you have seen that on about 3 or 4.
I think a couple of weeks ago, I had the Honorable Roxin Dafan, who is being touted as the quorum merchant now.
Yes. Well, that is an unfair description of the young active,
he has been raising some of these quorum issues.
Yes, but
people have even questioned his motive for raising it, actually.
I think that what the Honorable Roxin Dafan sought to do was to, make it patently clear to Ghanaians the absurdity in Abdullahi.
It's almost like you guys are shadow boxing that decision.
We are not
in all of your decisions now, in all of your actions now, your decision to raise quorum on the floor, your decision to go to court, your decision sometimes to even stay away in the recent one. There is almost a clear-cut link anybody politically can connect. That they are still having problems with that decision, and it plays out today too.
Well, why not? Abdullahi, overturned what we did.
Yeah,
he did.
That's the problem.
Right? And it kind of caused an upheaval in the mechanics of lawmaking, in the mechanics of deliberation, on matters, of importance to the public, and so on and so forth.
But court that will make a decision like that, won't it be?
Well,
when there are certain matter, it clearly would have to lie with the court, especially the highest court of the land, to make some of these determinations.
I agree. Yeah. When there is an allegation that the Constitution has been breached, right, it is only the Supreme Court. And his Lordship Justice Yoni Kulendi was right in saying that it is only the Supreme Court that can assume jurisdiction in such circumstances. All right. But after assuming jurisdiction, you have to take into account, all the issues and all the matters that are important to the making of the decision. So for instance, I thought that he would have gone deeper into the law and custom of Parliament. All right, in making a determination as to whether
was that what he was invited to do?
Yeah, but it is part of the exercise of judging.
All right,
it's part of the exercise of judging. I thought that he would have done that, because you see, ultimately in I think at page 24 of the decision, right? I think is it page 24? He then comes back. The Supreme Court, of course, he was writing for the unanimous bench of the Supreme Court. It then comes back to say that in the circumstances, right, Parliament should take a look at its standing orders. Now, what are we saying here, or what are we being told here? We are being told to go back, all right, to the law and custom of Parliament. The law of Parliament is the standing orders of Parliament, as supplemented by the customs, practices and conventions that have been adopted by Parliament. So, for instance, we go to committee, right? In the course of the work that we do, there are committee sittings. When committees are sitting in any ordinary day, the members in committee don't usually join the chamber for the conduct of business. But that doesn't mean that they are not in there. Then the votes and proceedings will reflect that they are in Parliament, but you don't see them in the chamber. All right. And Mr. Speaker knows that there are a committee. There is committee work that is going on that will ultimately land on the floor of Parliament. Under those circumstances, to say that at every point in time we must leave the committees and come and populate the chamber to be 138.
Is that the interpretation of it?
Yes.
Because some have also raised the point.
That's the practical effect.
Present doesn't necessarily mean that you should be. Those who are questioning the walkouts, They're also raising the point that you can be present by logging into the, what they call it, attendance book, which means you are present in the Parliament of the Republic of Ghana.
Okay.
And that can even be enough for the quorum requirements here.
Oh, that is a very interesting interpretation.
You've heard it, right?
Yes, and I agree with it.
You agree with it?
I agree with it. If that interpretation holds,
yeah, that means that you in the minority, we're in the Parliament.
No.
Because you talk different.
Our earlier decision to throw out the budget will be valid.
But that's
no, on that, I mean,
I get you, but that's
parity of reasoning, our decision to throw out the budget will be reinstated.
Because you'd have said that the minority, even though they walked out, the majority, even though they walked out, were still members of Parliament.
The votes and proceedings, reflected them on that day. So by parity of reasoning, then our decision should be restored. I mean, as having the budget. I mean, having thrown out the budget, which means that even yesterday's E-Levy is, unconstitutional.
Really?
Yes.
Now, before we take a break, and maybe, we need to take a break. When we come back, there are also outstanding questions on this particular matter, but it's more importantly a question going forward.
Okay.
What can be done to make sure that some of these things are not consistent? Because now it's almost like a permanent quorum issue is happening in Parliament.
Right.
At the core of this conversation, it's not even E-Levy in and of itself,
right,
but it can be happening to any other bill anyway.
Yes.
But it's also the issues of you running Parliament the way it ought to be run.
Right.
After the break, we'll continue our conversation with Dr. Aine.
Thank you.
You're welcome back. This is Upfront. We are interrogating why the NDC in Parliament, the minority, is in court, dragging the Attorney General and seeking that E-Levy vote that happened yesterday. They want the court to say it was unconstitutional. They want the court to wipe the slate clean of E-Levy, the one government says has been passed, the one that the Parliament of yesterday passed. That is the crux of their issue. The most important argument they are raising is that the recent decision of the Supreme Court was clear on the matter. They believe the Supreme Court said clearly that before you can take a major decision, you need half of members of Parliament present. They in the minority walked out. By walking out of that particular Parliament, they deprived that Parliament of the ability to get half of it sitting. And that is the reason why it could have continued with the passage of the E-Levy. That is the crux of their issue. It brings up other related, and it's not a legal matter in and of itself completely. It has political underpinnings, I'm sure by now you've gotten to the point. Yeah. But my guess is Dr. Aine. He's a major legal brain of the NDC in Parliament, even out of Parliament. He's a former deputy, Attorney General too. So, and in Bogatanga East, he's the member of Parliament there. It's unclear how long he will stay as member of Parliament there, but he's still currently the member of Parliament there. You're welcome back, sir.
Thank you, sir. Thank you.
So we left on two things. The argument you have put before the court, and I've seen your reliefs, they are basically making the same argument.
Yeah.
Just that at any point in time, want the court to say that, yes, this is our proper interpretation. Yes, this is how it should have been done.
Yeah.
Yes, they didn't comply with that proceeding. And finally, the E-Levy of itself could not have been passed by 136 members of Parliament sitting. That's basically what you're saying.
That's the crux of our...
Now, we left off with that question as to whether or not, what presence mean. Whether when you log in you are present, and whether when you don't log in you are present.
Okay.
And whether you need to be seated in the chamber, because you first argued that even though he was seen maybe close to an ambulance, the member of Parliament Kojokum couldn't have been said to be on the floor because you didn't see him on the floor.
That is so.
You make that particular argument.
Yes, I make that.
Is there any indication in Abdullahi that clarifies this matter and puts it to rest?
Well, I don't think Abdullahi actually dealt comprehensively with this issue of present, and voting.
Okay.
I mean, the court in that case was much more interested in the the right of the first deputy speaker, to participate in the process for the determination of a quorum.
Okay.
All right, because of the challenge to the quorum provision that was raised by the plaintiff in the case. But I think that ordinarily, when a member of Parliament comes to Parliament,
okay,
and then the process is a very simple one. You have a list of the names, and you sign against your name. All right. The votes and proceedings will reflect that on that day You were in Parliament. You attended Parliament, or, Parliament.
Which is very possible. You can stay in the washroom for an hour and not be part of a vote.
That is so. That is so. Or you can stay in committee. Okay. You can do committee work.
I thought that's why they ring the bell for everybody to come to the floor.
That is if a quorum is raised.
Okay.
If a quorum is not raised, the bell is not rung.
Okay.
If there is no call for division, the bell is not rung. And so we go on as if there is quorum, until it is raised. Okay. So for purposes of the determination of presence in Parliament, right? Mr. Speaker, the Honorable Alban Bagbin, himself a very, very, very seasoned, parliamentarian, very experienced, one of the most experienced parliamentarians and the most knowledgeable persons when it comes to the parliamentary procedures, had said that for him, presence means presence within the precincts of Parliament. All right.
Okay. Is that why he proceeded?
Yes. So the point,
the Speaker's original argument, even then, was when the majority left in that previous one.
Right.
He didn't find anything wrong with that. We proceeded with parliamentary
because he was right in that sense, because I could be in the committee room.
Okay.
All right. It will be wrong, and then I would have signed in. It will be wrong to say that because I'm not in the chamber, okay, I'm not present in Parliament. It will be wrong. I mean, it will be a very obtuse and unuseful interpretation of the rules and procedures of Parliament to say that I was absent from Parliament. I was not present in Parliament. All right. But the decision in Abdullahi pushes us to a situation where presence in Parliament, all right, means present in the chamber of Parliament and then participating in the vote.
Was that categorical?
Well, it's not categorical, but that is the reason. Shall be determined by votes of majority of members present and voting, right? Possibly, you could say that because voting only takes place within the chamber of Parliament, then presence could only mean present in the chamber of Parliament.
That's an extrapolation,
right? That is an extrapolation. So, I mean, if you, for purposes of a decision, right, if I am in a committee room, and let's say that we have electronic voting, and a decision is up, for voting, and let's say that I press, my voting preference, whether yes or no, all right, and it goes to the screen.
Okay.
Was I in Parliament, present and voting?
There's important, because at the core of COVID, I saw in the UK Parliament parliamentarians voting via Zoom.
That is so.
And joining via Zoom to do
that is so.
Votes.
So in fact, I think the Right Honourable Speaker himself had suggested, because we have a project ongoing, which is the E-Parliament project. Yeah. So he had suggested that we should consider during the COVID, holding some of our proceedings, online and getting members to participate and so on. All right. In those circumstances, I mean, is anybody right in saying that because you were not physically present in the chamber, all right, you were not present for purposes of the determination of a quorum under Article 1041 of the Constitution? But
that's also an important strand. Yes. Is it also up for determination by the court?
Oh, not exactly, because
it's not a question you're asking here.
No, because in terms of the factual basis of our rate, we are not seeking to say that.
There are those who have said that if the court had dealt with the Richard Sky case and not dismiss it, it would have answered this question.
Well, the court said that it had the issues in Richard Sky were moot.
Okay.
Because of the decision in Abdullahi, but I disagree. Because they dealt with a completely different set of issues.
It's more like a quagmire. It's more like a very confusing position we are currently.
Right.
Can we ever settle these matters and return to the Parliament that's most of its job without controversy?
Well, I think if we act in accordance with principle, if we act, by building consensus, as political parties. Okay. Okay. So that it is not a question of one party dominating the other and so on. Okay, we can resolve these matters. They are not irresolvable. It's not rocket science.
Okay.
But so it is just a question of acting in accordance with principle. So, for instance, I mean, I do not see how we can be dragging the judiciary, every day into
some
matters,
of these procedural matters
into these matters in Parliament. All right, because the doctrine of separation of powers, makes it possible for the three co-equal branches of government, to defer to each other in terms of decision making. Now, when you talk about voting in Parliament,
did the judiciary not put their foot in the doorway?
I think they have, because you see, for instance, let me give you an example. So the Subsidiary Legislation Committee of Parliament, which I chair, is currently considering the standing orders of Parliament. All right, we are adopting new standing orders of Parliament. Right, Abdullahi says that since we have power under Article 110 to formulate our rules, we should formulate them in conformity with the Constitution. Yeah. Right. I mean, we think that what we have done so far has not violated the Constitution. But supposing that after passage, a member of Parliament says, no, I don't agree with what you have put in the standing orders. I think that it offends the letter and spirit of the Constitution. And then the person goes to the Supreme Court. And the Supreme Court says, you know what, we agree. So the Supreme Court strikes out our, standing orders, right? Where are we headed with that kind of decision making? Okay, where the court is now being called upon to, interfere in determining the law and custom of Parliament, which is the exclusive preserve, and that's why we are of Parliament, because that is why you often hear that Parliament is a master of its own procedure, but it's subject to the Constitution.
That's true.
So that is why my problem with Abdullahi is that Abdullahi does not specifically say which constitutional provision was offended by the standing orders that said that a first deputy speaker presiding has neither an original nor a casting vote. It is because we have drawn an inference from the Constitution. The Constitution itself has said, I think in 1043, that where you are, the speaker or the presiding officer, you have neither an original nor a casting vote. Now, when a deputy speaker, whether first or second deputy speaker, is presiding, that person assumes the rights, powers, privileges, and immunities of Mr. Speaker.
And then it's qualified here.
What?
I'm saying that those rights are qualified with Abdullahi.
No, basically what Abdullahi says is that you retain your right to vote,
to be a member of Parliament,
because you are a member of Parliament, and because you represent a constituency, you can be counted for quorum purposes, and then you can also be counted for purposes of voting. But let me give this example. So a first deputy speaker who is presiding calls for a voice vote. He says those for the decision say aye, and people say aye, the members say aye. He says those against the decision say no, and then the members say no. Did he participate in saying aye, or did he participate in saying no?
Is that way of determining that the voice vote? Well, we can't determine unless there's a subsequent head count, right?
But you see, when then there is a call for division.
Okay.
All right.
Yeah.
Which is one of the practices to determine numbers, for purposes of decision making in Parliament.
Certainly.
Where there's a call for a division, right? Now, the person who didn't say, neither said yes nor no, is now going to be counted for purposes of determining whether or not we had the requisite numbers.
He was not part of the earlier vote.
No, he wasn't.
How could he be part of a division on the earlier vote?
That is the question, because you see, the voice vote, all right, is taken, as determinative of the matter, unless it is challenged, because somebody thinks that he heard more no's than yes.
Okay.
So,
but then an MP who did not participate in the voice vote outside come and join for the division?
No, he cannot.
He cannot join?
No, he cannot.
Oh, now, I have maybe the last set of questions I'm asking you. So where are we now? You filed the case, right?
Yes, we have.
Where are we now? What are the processes that will lead from now to determination?
Yeah, so the writ has been filed. We'll be following up with the writ with the statement of case. That is a set of, we'll narrate the facts in the statement of case, and then the issues for determination as well as the legal arguments.
When will the court set a date to deal with this matter?
I have no idea.
Would it be determined just like the way Abdullah was determined, with speed?
I hope it is determined with speed, because this is a very critical matter.
We are told that E-Levy will come into fruition in May. Would it be determined before that time?
I am hoping that the court does so before the E-Levy.
I heard things like stay of execution and all of those. I mean,
no. You cannot stay execution where there's no order of a court of competent jurisdiction.
Okay.
So dismiss that. There was no stay of execution by the NDC or anybody for that matter.
Okay.
The writ was filed today. Around 9 o'clock or so.
Can you stop implementation of E-Levy before May 1?
If the court hears us in April and determines that the E-Levy vote was unconstitutional, E-Levy will not be implemented.
I'm talking about if the court starts the hearing.
No. It will be difficult to get an injunction.
Really?
Yeah. Because it's the actions of a public authority. It's very, very difficult for the courts to agree to give an injunction against a public authority. Because when E-Levy is passed, it is a GRA that will be collecting the tax.
Yes.
All right. So you really need to be very, very, very precise about the harm to the public interest.
Okay,
that will ensue if an injunction is not granted. In those circumstances, the court may be willing to grant an injunction.
By this case, are you putting the court in a tight corner?
I don't know. Our intention is not to put them in a tight corner. We are just inviting them to enforce the Constitution in accordance with principle. That's all.
Now, there's a final question that you should answer here. No matter what happens, do you expect the court to rule on this matter between April and May, where E-Levy is supposed to be implemented?
I hope so. It is my expectation that their lordships will see it as an urgent matter, as urgent as was determined in Abdullahi.
Is there division among you in the minority?
No, there's no division. We are all united behind the Honorable Haruna Idris.
Is there a presumption that the minority has been bribed? That's why you chose this option.
Well, I think that Ghanaians must learn to trust, its public officials. There's no evidence whatsoever that any one of us received money in exchange for the decision that we took yesterday. There is a certain cynicism that is creeping into public life.
Yeah.
And I do understand why people are, cynical about us. But I think that it is important to also trust us, as the elected representatives, that when we take a decision, we are doing so in good faith and in the public interest, and that we are not, doing so because it's transactional, that we have gone to the other side to take money and so on. Raymond, I can go to Zorngo and do farming. I don't need to take a bribe.
But yet you chose to teach at the University of Ghana, have a big law firm with a lot of money involved.
Oh, come on.
Anyway, but the last question, same chance of winning this case?
No, I think Inusa is wrong. With all due respect to him, he's wrong. He's trying to invoke the doctrine of estoppel. We are not estopped. In 2004, an Attorney General, it was very clearly stated that estoppel cannot be raised in constitutional litigation. So I don't think that the Honorable Inusa Husseini is right. I differ from him. We are very good friends, but I think that on this occasion I would say he's wrong.
I'm grateful you had time to join us.
Thank you very much,
consistently. Folks, that's when we end today's edition of Upfront. Many thanks to you for watching.
Yeah.
And thank you so much, Doc, once again.
Okay, all right. My pleasure.